the National Assembly has approved of a controversial proposed education law. The Basic Education Laws Amendment Bill now goes to the Council of Provinces. It states that the admission and language policies set by school governing boards must be approved by the provincial head of education. The Education Department says that's to ensure that schools do not use these policies to exclude any learners. But some parties say it's an attack primarily on Afrikaans schools. The ANC, EFF, IFP supporting the bill, but it's been rejected by the DA, ACDP and FF Plus. To discuss it, we're joined by DA MP and Shadow Minister for Basic Education, Baxolile Ndoda. Mr. Ndoda, thank you. You say that the bill will disempower schools, parents and communities. How?
Look, we've been unequivocally clear as the DA that we don't support the Basic Education Laws Amendment Bill in its current form. As much as we support educational reform, we can't support a law that is basically taking us back to a Bantu education style type of policy where there's centralization and control by the state to dictate to schools and communities and parents as to what language of instruction they need to use in their schools. This particular law is trying to strip school governing bodies from determining the admissions and language policy. The reality of the situation is that it is SGBs which are representative of teachers, of parents, learners in those schools that know the capacity of the school so that they can determine the number of learners they can take in terms of admissions so that learners don't end up in overcrowded classrooms. Number two, it is those communities and parents that know what is best in terms of the language that may be used in that particular community that will best respond to mother tongue education. And it's been proven world over that when a child studies in their mother tongue, they can read for comprehension, for meaning. And that is exactly what we need to be promoting: quality education, quality mother tongue education. This particular is basically regressive in terms of that. And it actually does not deal with the real issues in the basic education sector. We've got overcrowded classrooms, as you may know. Children are still dying in pit toilets. There's roofs and infrastructure falling on children in schools. Poor quality teaching in the classroom. Like I mentioned, children can't read for meaning. If we're going to change the laws of the South African Schools Act and the Employment of Educators Act, they at least need to be responsive to the real issues. And that's precisely why you objected to the bill at the moment.
Okay, but let's look at the concern here. And I think there have been situations in the past where schools have set criteria, say you need to speak Afrikaans, or you have preference if you had siblings at the school, things like that, which could keep traditionally white schools white, exclude other communities, even living very close to the school. Is that not an issue that does need to be addressed?
You see, when you're making laws, you must never make laws for the exception. What we have suggested is that if there are schools that uses the admissions, language policy, or any other form of policy that is developed by the SGB, the law must have a recourse mechanism where a parent, a member of society, can be able to lodge a complaint for the HOD or the MEC to intervene in those cases. The reality of the situation is that there's only 5% of single language schools in South Africa. And the current ANC government is trying to scapegoat these 5% of schools, 1,200 schools out of 24,000 public schools that are only single language of instruction. And the Constitution basically protects those schools to be able to, for parents to be able to make a choice that I want my child to go study in their mother tongue because they are most likely to get a good quality education. And if you look at the Bill's results, it indicates that the learners that did the reading for meaning test in their mother tongue had a better comprehension score than those that utilized, for example, a language that's not their mother tongue. So instead of scapegoating these 5% of schools, we need to be promoting mother education across the board so that I can study maths, accounting, science in my isiXhosa, which is going to give me a depth of knowledge rather than a tick box exercise. And the ANC government must be able to take accountability for this. In the past 30 years, they haven't developed any indigenous language. And that is exactly why they are then saying today that they're scapegoating Afrikaans schools or single language of instruction schools. It's an indictment on them. But what we can't run away from is that there are cases and situations where schools may use these policies to discriminate against learners, and the recourse mechanism must then exist in law so that the HOD is not a player and a referee, but they play the important role of being an arbiter and a referee where there are cases. But let's not make laws for the exception and then want to scapegoat 5% of schools.
But is that recourse there right now?
The recourse right now is actually a contradiction in law, because the HOD then approves or rejects a policy. And if a school or parents and communities have a problem with that policy, they then have to go back to the same HOD. So how do you become an arbiter in your own case? Because you are being a player and a referee. And that on its own is problematic. That's why we're saying these school governing bodies, parents have an important role to play in the education of their children. And it's been proven in the world studies and research that parental involvement in schools is critical. So let them develop their policies. They must be in line with the Constitution. They must be in line with existing legislation, and then have a recourse mechanism in law to say, HOD, if there's a problem, please intervene. At the moment, the HODs in provinces are both players and referees.
All right. What do you think of the other provisions of this provided for law, making grade R compulsory, so students have to go to school earlier, jail time for people who don't send their kids to school, no punishment, things like that, corporal punishment?
Look, there are some elements of the bill that I think are commendable. For example, we support the fact that grade R must be made compulsory, because early childhood development as well as primary education is very important for the cognitive development of a child, so that they're able to read for meaning. They've got the numeracy and lit skills up in the game. And however, we've got a big challenge when it comes to making grade R compulsory, because on a basic level, the department will require 12 billion to make sure that they employ teachers, they build the infrastructure that is needed for those schools, and there's a national school nutrition program for those learners. So as much as it's commendable, it's important for them to indicate to us where the money is going to come from, because Treasury said it's an unfunded mandate. Where we also have an issue, for example, in the bill, is that it's trying to regulate home education, where parents choose to educate their children at home and basically want to send independent assessors that they need to pay for, despite the fact that those parents already sacrificed one salary to home educate their children. And ultimately, the bill itself also misses a very crucial opportunity to regulate online and blended learning, which COVID has shown us is a form of learning that is here to stay. And I'm sure you would have seen there's a lot of pop-up schools that are of that nature, also assist in terms of overcrowding in classrooms. So it also does miss that opportunity, and misses an opportunity to deal with the real issues. But there are some elements in the bill that are commendable. That's why we're saying in its current form, we don't support. And if these elements can be corrected, ultimately we'll consider supporting.